Hi, my name is Jonathan Culbertson, and I am the Senior Compliance Manager at InCheck, a background screening company. Welcome to the January 2025 edition of InCheck's Compliance Update Vlog, which briefly features some recent legal updates that affect background screening and the hiring process so that you can take that information back to your teams and legal counsel for further review. Okay, let's get started today with a fair chance update. Madison, Wisconsin's Equal Opportunities Ordinance states that it is unlawful for employers to discriminate against any individual because of such individual's arrest or conviction record, absent certain exceptions. So there's some exceptions. Recently, the Madison Common Council amended one such exception to state that discrimination because of an arrest record or conviction record is not prohibited if the employer can show that the employee or applicant has been placed on probation, paroled, released from incarceration, or paid a fine for a felony, misdemeanor, or other offense, the circumstances of which substantially relate to the circumstances of a particular job. So if the offense and its circumstances substantially relate to the circumstances of a particular job, it is an exception to the general rule. Now, notably and importantly here, there's no longer a requirement for the employer or the applicant to have been placed on probation, paroled, released from incarceration, or paid a fine within the last 3 years for an employer to be able to rely on that substantial relationship exception. Doesn't have to happen within the last 3 years. Okay, next let's visit the recreational marijuana law in New Jersey. So the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act prohibits employers from doing two things, okay? One, from taking any adverse action against any employee because that person does or does not use cannabis items. And also, two, it prohibits them from taking any adverse action solely due to the presence of cannabinoid metabolites in the employee's bodily fluid. Now, recently in Zaintic versus Walmart stores, the United States Court of Appeals for the Third Circuit held that New Jersey's recreational marijuana law does not provide a private right of action for an individual to enforce the law's employment protections. So they said there's not the right to bring a civil action to enforce the law's protections. Okay, let's finish up with a quick update on DOT drug and alcohol testing. The Department of Transportation announced the 2025 annual minimum drug and alcohol random testing rates for DOT agencies. The random testing rates are the same as they were in 2024, with the exception of the Pipeline and Hazardous Materials Safety Administration, which has increased its random drug testing rate to 50%. Well, that does it for me for the January 2025 edition of Compliance Updates. Thank you for joining me, and please join me again next time. Take care.